Welcome to Higher Education Law, the Torts Lecture. This will be hopefully the only lecture that I have video like this, as I'm not particularly crazy about doing videos like this. And this is my first time doing this type of video, so there's not going to be a lot of editing in of slides. You can have your slides up next to you as we go through them, because I'm going to reference those slides. And so if you catch me looking off to the side, that's because I'm looking at the slide references to make sure that the points are the same issue. We're going to talk about torts in a general overview sense today. We're not going to go into each of your individual cases. And then in our next in-class lecture, I believe on the 26th, we are going to revisit a little bit about torts, revisit a little bit about faculty and education, and also talk about some admissions and grading and financial aid. It's one of our areas where we can slide down a lot. There also will be some links to articles sent to you that I hope you get a chance to read those articles and start thinking about them in the generalized legal sense. But let's dive into torts. The first two slides I've provided you after the title slide really takes a look at what United Educators, which is an insurance company. They're one of the largest insurance companies for universities and colleges. And what UE put out is a list of what types of claims come forward. And so you can see the different types of tort claims on the third slide there when you look at slip and falls and assaults and vehicle accidents and tort within athletics. You get to take a look at those general liability claims and how many of them there are and start looking at the costs. And when we get to a little bit later in the lecture, we'll talk about the real life costs of these types of claims. A tort, by just pure definition, is a civil wrong other than breach of contract for which the courts will allow a charge, damage remedy. And damage remedies are money, generally speaking. There can be some other types of remedies within tort, but generally speaking, it's going to be money. And the reason it takes contracts out of there is because contracts is a separate area of law in its entirety. And when we talk about contracts with students and contracts with faculty, like we did a couple of weeks ago, those are a different area and analyzed in a different way than torts are analyzed. Tort is what you usually hear as plaintiffs, civil liability. Plaintiffs' lawyers tend to be tort lawyers. The ads you see on TV about the guy who's like, one call, that's all, and you've been in a car accident. Those are all tort claims. So it's that civil wrong that somebody did to someone else. And you've also included the Black's Law definition for you on the next one. So you have the student affairs definition, sort of the general Black's Law definition. I want you to have both of those. And what a tort is that wrong that's been done where somebody's been lost something, usually money, but also can be loss of life, injury to oneself, and we'll talk about all that. The standard of proof used in a tort claim is the preponderance of the evidence. And the reason we use the preponderance of the evidence is because only property is at stake here. When you look at the different standards of proof, and we're going to revisit this when we get to particularly student conduct and employee discipline, the standards of proof that are used are beyond a reasonable doubt, clear and convincing, and a preponderance of the evidence. Those are really the only three standards that come into play. Beyond a reasonable doubt, we use in criminal cases and only criminal cases because life and liberty are at stake. You can be sent to jail, you can be killed for capital crimes in certain states, but that's the highest stake. So we want to make sure the highest standard of proof is used. You'll also hear these referred to in those cases as a burden of proof because one side does have a burden of overcoming the standard. So what I mean is the plaintiff has to prove that the defendant was negligent beyond a preponderance for a civil claim. And in a criminal case, the prosecution, the state or the federal government, has to prove that the crime and all the elements of the crime were committed beyond a reasonable doubt in a criminal complaint. Clear and convincing is used in some civil cases, some securities cases, some child cases that involve children. Not a very common standard. If I think about it, if you really have to kind of wrap your head, beyond a reasonable doubt, it's like 95%, 99%, somewhere in there. Clear and convincing is like the 75% standard. And then the preponderance of the evidence standard is the more likely than not 50.1%. The scale tips just a little bit, and then you have that change. So that's the one we use because money is at stake. Now, when you're looking at the different kinds of ways colleges are held responsible, colleges are not going to be held liable, generally speaking, for all the acts of their students, for all the acts of their employees. For employees, the employee needs to be acting in the scope of their job in order for the college to be attached to that. So when you're doing your job, your employer, it's a part of law called respondeat superior. It means the employer is responsible for you being your employer for the acts you do as long as you're acting within the scope of your employment. If you step outside that scope, for example, you're charged with doing something and then you cause some other harm to someone else, but not in the scope of your employment, you would be held liable, not the institution. But of course, a plaintiff's lawyer is going to want to attach the institution because institutions have better insurance than you and they're richer than you. That's the nature of institution. Generally speaking, students would not be held liable unless they were employees. There are some narrow instances that when we get to the college student and the student, we'll talk about ways institutions could be attached. And I'll give you a little preview. Start thinking about fraternities and sororities and sports teams and other recognized student organizations acting within the scope of that recognition. And that may cause that situation to occur. So moving right along, let's talk about what the legal elements of a tort claim are. And this is probably the simplest one for you on slide 7, duty, breach, injury, causation. I've just simplified 2 semesters of first-year law classes into one slide. And that is, in essence, all the elements of a tort. Now, we're going to do a little bit of a deeper dive because you have to understand how each of these are analyzed. But generally speaking, duty, breach, injury, causation are the 4 elements. The operative question, it really depends. But when you look at the way the questions are asked, the first question is, did the defendant owe the plaintiff a duty? Did the university owe the party who was injured some sort of duty? And we'll talk about what those different types of duties are in just a second. The second question then is, was there a breach of that duty? And that question is really asked in this way. Did the defendant, by act or omission, by act or failure to act, breach the duty to the plaintiff, the injured party? Third question, was the plaintiff then injured? Was the plaintiff actually injured by that breach? And then the fourth question is the breach, and the term used in the law is proximate cause. So was that breach of the duty the proximate cause of the injury? In other words, but for that breach, there would have been no injury. And that sounds simpler than it is, and we'll talk about some cases. And for those of you who briefed cases, you saw this sort of analysis in the brief and how the court had to take a look at it. There's some real interesting pieces to this that you really do want to know about in terms of the reality. The reality when it comes down to it, when you're doing an analysis of a tort claim, when a plaintiff's lawyer is doing an analysis of a torts claim, the real analysis is, can we recover? And not recover in the sense of can the plaintiff get better, but can the plaintiff recover money from the defendant? So can the student or the employee or the visitor or whoever it is get money back from the institution? As you can see, most of the claims going back to that come from negligence issues, some failure to protect or something like that by the university to the student. And so there's all sorts of different ways that comes to light. You saw those in some of your cases. We're going to talk about some cases. I want to do a little bit of a deep dive into the Shin case as a good example of how the courts are even split on this. But negligence and defamation are the 2 that pop up a lot. 99% of these cases settle, maybe more. The vast majority of them settle. You'll also hear me refer to some of these cases as, not the cases we're going to talk about, but some of the cases that come, there's a nuisance suit aspect to this, and it's kind of like the Walmart theory that, if you slip and fall in Walmart and you sue Walmart, they have an amount of money that they've kind of set aside to say, we'll give you this if you just won't sue us. It's what they've determined to be the cost of litigation. It's what they've determined to be the cost of reputational loss. They've made a number of determinations to come to that number. And it's generally speaking underneath their insurance number as well. So these insurance things are going to keep popping up to one another. When you look at the different types of duties and obligations that we have, we'll talk about business invitees and things like that. But again, 2 words I want you to see that you'll see continue to pop up are was the harm foreseeable or was the risk unreasonable? And so think about the cases you saw And was that harm foreseeable, which is a big one, or was the risk we made the person take unreasonable, is another one. And we'll keep revisiting those, especially in class. We'll talk about what types of harms can befall individuals and what kind of things could be considered unreasonable risks. You think about, I'll give you a quick example. A professor goes on a field trip with students and asks them to walk across, and we'll actually unpack this in class a little bit more if you want, walk across an icy bridge in order to see a geological monument that they think is important for the course of geology. And so if a student falls on that bridge, was the professor making that student cross the bridge that present an unreasonable risk to that student who was injured? And there's some stops along the way that we'll unpack further. I want to move on to the next slide, to slide 9, which is duty. And the different types of duties that can happen, that could come up, the most common on the next slide, are business invitee, landlord-tenant, and then in the law what's created, and you'll see this often referred to also in your cases, they'll reference, instead of a case or a statute, they may reference the restatement of torts, which is books that are put together by legal scholars that don't have the weight of law, but they're often cited because they are the scholars that are invested in torts, that understand torts, and they say this is what this tort means. And literally once in a lifetime they get together and issue these restatements to try to keep up with what's happening on the ground in terms of the evolving cases. You think about how fast technology's evolved and the risks that can be involved there, reputational, etc. Business invitee is exactly what you think it is. It's if somebody's invited onto your campus to do business, if any of you do any sort of consulting work, or if you were a stand-up comic, if you were somebody doing performance art of any sort, if you are asked to come onto a campus to do contracting work, you are a business invitee, and that campus owes you a reasonable duty of care. And so they have to make sure that the premises is safe. That's called premises liability, that they've given you and provided you a safe environment, or at least a reasonably safe environment to work in. And that may come to pass from the university. It may come to pass from your subcontractor employer. There's a variety of ways, but somebody who's invited on to do business is a business invitee. For those of us who work on residential campuses, that resident campus is a landlord-tenant relationship, and there's a reasonably safe premises that doesn't have rotting staircases, and you get a fair number of lawsuits that come from railings that are broken or holes in the sidewalk, or we had a couple of cases back when I was at Carolina that involved the air conditioning units and the relative safety of those in terms of the filters, and can they prevent diseases that can get through, and how well are they maintained. So you can see that landlord-tenant relationship has a lot of pieces to it. The one that's not listed there you might want to think about too is also common carrier. And that common carrier relationship, think buses. So if you have a shuttle bus system within your campus, or any other sort of common carrier vehicle that you use, vans and things like that, that common carrier can attach itself. Different than if you take the occasional motor pool car that you take out of the motor pool, or the van that you take out of the motor pool to go on a every so often trip. The common carrier really extends to those things that are carrying large numbers of people on a regular basis. When we can't find a relationship to attach a duty to, then we use what's called the special relationship. But then we have to attach the type of duty that exists within that special relationship. For the purposes of student affairs, liability, and tort, it's safest just to know that we do have a special relationship with our students. That is well established at this point. There's no way for us to say we don't have one. It would be a bad argument to try to make at this juncture. So then what would you look for? Duty to warn. That icy bridge scenario, does the professor say, hey, we're going to be crossing an icy bridge, wear appropriate footwear? Does if you remember from your reading, you look at the case where the young woman is assaulted on an off-campus at an off-campus venue that she had to go to. She's attacked. How safe was that venue? You're going to see, we're going to have a lot of these cases pop up, both under tort liability and some other areas of law when we get into the college relationship with the student. Duty to provide proper supervision. Think about the cases involving whitewater rafting and scuba clubs and athletics teams and club sports and intramurals And it's not just the type of supervision like boss and supervisor employee supervision. It can go beyond that as well. Duty to provide instruction, which means we have to provide adequate instruction. We have to provide, and by adequate, there's a broad range of that right now, but you think about instruction in courses where there are inherent safety risks, welding, HVAC, car repair, all the things where there are inherent risks to behavior. Embry-Riddle University is a university that is primarily about the maintenance and piloting of aircraft. There's some inherent risks in there, so the instructors better know how to fly planes and have logged enough hours and be legitimate instructors. And so we have to do the best to try to prevent or at least stop the harm if we know it's going to be there and we can stop it, or do our best prevention or our best warning. And these are the pieces to that puzzle that are critically important. The determination of the existence of the duty is an argument of law. I think you really need to understand that the court makes that determination whether or not the relationship exists. And we talked earlier about arguments of law versus arguments of fact. Law arguments are done by the judge, so that whether or not that duty exists, and there'll be motions filed to say we don't have the duty, we don't have the special relationship, here's why we should be cut out of that and leave the party who actually did the harm alone to suffer the burden as the defendant, as opposed to attaching us, the institution. That's going to be an argument that's going to be decided by a judge. And so that piece is out there. And again, looking at that duty once we get past it and once we make a decision, or the court makes the decision, there's a duty to, you have that relationship, it's given birth to that duty. Now we start thinking about the foreseeability of the harm, the unreasonableness of the risk, the nature of that risk, the causation. If you look on your next slide there, I think it's slide 11 for you. I'll zoom forward here. And then the relative causation attachment between the act or failure to act and the injury to the student or the party. I put student in there, but it could be really anybody can sue the institution, obviously. Then you look to the next set of relevant factors and you think about moral blame and responsibility, the ethical decision-making that went on in that. Do we want to hold this campus liable because of the social policy of that? You think about the bonfire case from Texas A&M University, where they determined that the bonfire, a completely student-run enterprise, was an example of a thing they called state-created danger. And when you look at state-created danger, having that attached like that, there's a social policy that you want an institution that has a tradition like bonfire. If they're going to continue it, you want to make sure that they do it responsibly. And so that public policy argument or social policy argument is a viable one, because we don't want future harm. You wouldn't want another bonfire tragedy on that campus or any other. So there's some policy reasons for holding the institution liable. This is jury trial stuff. This is appeal of emotion stuff that can happen. Those public policy arguments, those appeals to emotion. And again, really one of the more operative terms, the burden on the university, the larger community, those are the reverse policy arguments that, hey, if you make us responsible for every tradition here, schools are going to stop having traditions altogether and we'll stop doing anything that's risky. And college in and of itself is a pretty risky proposition. And so we want to make sure that as we are pressing forward and moving forward as an institution, that you don't hold us liable so much for this that we couldn't ever have any sort of risky activity. We'll just cease doing anything of risk, and that's it. The real consideration is this: insurance, the availability of insurance. Individuals carry insurance policies. Sort of the higher up the food chain you get at your institution, the more you're going to want to be personally and professionally insured. But those insurance policies pale in comparison by a long shot as to the institution's insurance. There are plaintiffs' lawyers that, for students, will attach homeowners policies. When you think about looking at some of these judgments in hazing cases like Furyk and some of those, where that money comes from is not just from the students themselves, but also from their parents and their parents' homeowners policies and trying to attach those. And then obviously there's also going to be malpractice insurance when you think about health science centers and the allied health professions, the nurses, the pharmacologists, counseling center programs, social work programs, med schools, law schools, all those places that do work, there's malpractice insurance involved in that. So if you are an accountant and you're, say, getting your master's in accounting and your CPA, and you start doing like free accounting for people or free tax work before you're licensed to do so, you're doing that under somebody else's license at the institution. And if they're doing that as a class, they're going to have some sort of malpractice insurance for the individual, and then the institution has also agreed to sort of take on that risk as we go on. So once we make a decision that the duty exists and we look at all those different relevant factors, now we want to take a look at whether the duty was breached. And again, if you look at the different cases involved in that, whether there's a breach, you want to look at whether something was done or was not done, failed to achieve. And when you take a look at some of these cases out there, and I'm gonna sort of revisit this very quickly, the Shin case. And Elizabeth Shin was a student at MIT who had a myriad of psychological issues. And MIT has a care team, as many institutions do, and they had a kind of advanced psychological team that was trying to deal with Ms. Shin. And what the court was looking at, and understand too, this case ends up settling. There's a motion for that summary judgment that we talked about earlier. There's a motion to dismiss. There's all these motions. And what ends up happening is it gets sent. The motions all fail. It's going to end up going to trial, and the parties, MIT and the Shin family, settle. What she did was took her own life. She set herself on fire in a residence hall and died a few days later of some pretty gruesome and graphic injuries. And so that case is, they're weighing out the likelihood of winning. But one of the questions was there a special relationship between MIT and Ms. Shin that creates the duty of MIT to provide a higher level of care for her? And when you look at their care team taking her on, being treated, I'll air quote, treated by the counseling center at MIT, when you look at the idea of whether or not it was reasonably foreseeable, whether she would harm herself without proper supervision, whether the institution had taken on more duty. And when you compare Shin to the Jane case, Jain, and Scheisler, both within your reading, and you look at, like, sometimes they attach a duty and sometimes they don't. And I just can't tell you that it's 100% predictable, because it's not. And that there's going to be arguments either way. There was a real concern, and when we talk about students in a week or so, there was a real concern in the Shin case that it would be damaging to those schools that had these behavior intervention and threat assessment and care teams. They might not want to do that because then they were taking on more responsibility. But if you look at the progeny of cases in there, what you start to see is people sort of expect campuses to take care of those students anyway. So if you have a student who is in distress and you just think to yourself as a campus, well, we don't want to do anything about that because then we'll act like we know something and we're kind of taking on that duty. Well, you've taken on that duty anyway. Once you know about it, the question is that foreseeability of harm. And then what did you do? And so it's better to have things in place to try to deal with this. So the question for that intervention team then isn't, do we have a duty to someone like Ms. Shin or Mr. Scheisler? Our question is, did we breach that duty? Did we fail to do what we were supposed to do? Or did we do something we were not supposed to do? And this is when we come back to class, I'll bring some examples with me of why you want to use objective rubrics. You couldn't get into the world of saying, oh, well, they're suicidal, they're out. One, ethically and morally, it's completely wrong to do so. And two, it's against the Americans with Disabilities Act. You'd actually be violating a different law if you start to eliminate people on the basis of their disability, of which suicidality and self-injury are recognized as mental health conditions, thus creating the protection of the Americans with Disability Act. So when we get to that breach question is, what did we do or what did we not do? And so the question in Shin goes back to, did that team do everything it said it was going to do? Did it take reasonable care? Did it exercise proper professional judgment? Were the decisions coming from it well-informed decisions? Were they taking appropriate steps with treatment plans, dealing with mental health professionals? There's a series of questions that fall within this as you're trying to say, Did they do everything they were supposed to do, or did they breach that duty? When you look at a case like Virginia Tech, I mean, a real big question for Virginia Tech in the murders that happened back in 2005 was, did Virginia Tech do everything it could have done to prevent those murders? And, the question is, how much information did they have? Could they have gotten more information? Should they have gotten more information? And when you look at the negligence claims against Virginia Tech, and in a moment I'm going to talk about state tort reform laws that exist in different states, because that's going to govern the state agencies. But then you also have the individual liability. And if you take a look at Dr. Roy and the lawsuits that were brought against her for making the argument that she failed to inform the institution about everything she knew about Cho, ergo the institution could not have acted in the way it could, just do everything it could have done. So you look at Virginia Tech, and then you look at Dr. Roy. On one side, you got Dr. Roy saying, you failed to tell Virginia Tech everything, ergo you breached your responsibility to the community that you have as an employee, and on a personal and professional level. You have Virginia Tech telling Dr. Roy, hey, that's your fault, not ours. And then you have Virginia Tech saying, but even with the information we knew, there's no way we could have done more. They end up settling all of their claims under their Tort Reform Act, or State Tort Act. Dr. Roy ends up eventually settling all her claims, but you can see how personal and institutional liability sort of come together in this. Because, of course, Virginia Tech's argument, if you're playing along in your head, could be, hey, she didn't tell us everything, so we couldn't have done what we were supposed to do, so you can't show that we breached our duty. And so the lawyers for the victims are arguing both sides. That Virginia Tech did had enough information to have prevented the harms and tragedies and should have had more things in place to do so, and B, that if they would have known more, they might have done better, but that Dr. Roy also breached her duty. And so they're fascinating claims as you go through them, personal and institutional. Once you have that breach, and you've established that breach, then the next thing is, what kind of injury are we talking about? And for you, that is going to be on slide 15, is injury. Different types of injury: injury to property, injury to person, and injury to sort of mental and emotional injuries are the three that you're going to see most often brought up. So when you look upon the different types of injuries, when we get to damages, this will make more sense, but generally speaking, you're going to be able to see the damage to the person. They've passed away, they've been harmed, they have different kinds of bills for this, or they've suffered some internal emotional harm. Those are really kind of the harder ones to get to, and we'll talk about those in a minute. Or there was some damage to their property. You think about a water pipe breaks in the residence hall and it does all this damage to the property. Obviously we have flood insurance that's going to pay for that, but if the student were to sue, they would say, hey, you should have known this water pipe was broken, and you would not have had this problem. And so once you get to that part, I want to make sure that we all understand. Let's see. And those are the three big types of injuries. And so once you get past injury, then you start looking at the causation, and that is the breach the proximate cause of the injury. I do want to stop for 1 second and mention two things that you're going to read in your cases, and it has to do with contributory and comparative negligence, and those are really just two concepts that are different from state to state to state. And in one of the concepts, when you look at contributory versus comparative negligence, each state manages their torts a little bit differently, and what you're really dealing with there is, in one set, if the party is 51% or more negligent, then they're negligent. They're negligent for all of it. In the other, you pay on the basis of how negligent you are. And so the court then has to make a determination, well, we think you're 30% negligent, and the school was 20% negligent, and this other party that contributed was 60% negligent, and you pay by a percentage of how much the final damages are. So understand, you'll see contributory and comparative negligence out there. When you look at those and you see those in the cases, it'll make sense as you read through the case. Don't get too caught up on that. The other thing you'll read when you see those also has to do with this thing called assumption of risk. And that is really a defense. It says that when you do a certain thing, that you assume some of the risk. When you play intramurals, you assume the risk that you might be injured playing a sport. There are some fascinating cases out there dealing with sport and the reasonableness of the injury that can occur during a sport. If you really want to read a completely non-educational case that sort of established some really interesting theories in that, I was privileged enough to work with a lawyer who actually did this case. It was groundbreaking at the time. And it was Tomjanovich versus the Los Angeles Lakers. And it involved a player who later became an NBA champion winning coach, Rudy Tomjanovich, who was struck in the face during a fight on the court between the Houston Rockets and the Los Angeles Lakers, and sued the Los Angeles Lakers for any number of things. But it really was a great case when you looked at the foreseeability of the harm. The man who struck Rudy, almost killing him, actually hit him one time in the face. He drops. You can take a look at the video. Probably Google it and you'll see the video of the hit. It's a brutal hit. Was known as an enforcer. Was known to regularly get in fights on the court. Was known to target certain individuals. And so the arguments of you knew the likelihood of this guy doing something bad, the security you put in place, the coaching techniques you put in place, a lot of different arguments about the foreseeability of the harm and the reasonable steps to prevent that harm. And did the Lakers engage in that? That case ends up settling as well for millions and millions of dollars. And so fascinating fact patterns that go on there. And then, of course, that issue of did that breach, so did their failure to do those things ultimately cause the harm to Mr. Tomjanovich? Is it but for those things, he does not get hit the way he got hit? Once the fight starts, should they have had security immediately look for the guy who's known as the enforcer, the guy who hits people all the time, the guy who has targeted individuals in the past? And so that's those questions that raise when you talk about proximate cause. So what do we have to do in summary? In order to recover, on slide 17, you have to prove that there's a duty, that and arguably you could put above that a relationship that created that duty, which is, like I mentioned, pretty much a foregone conclusion at this point. The duty, the breach, that the person was injured, and that the injury was the breach was the proximate cause of the injury. Of course, the big question in the real world is, can you recover, and how much will you recover? And that's what drives all the settlement rules and all of that. When we get into damages, you have three types of damages on slide 18: specific, general, and punitive damages. And so when you look at specific damages, these are damages which are measurable. You'll also hear them referred to, if any of you ever decide to work at a law firm or anything like that, as hard damages. These are medical bills, lost wages. These are things we can measure. You know exactly what it costs. When you get into general damages, these are damages that cannot be measured. These are where you hear things like pain and suffering, emotional damage, loss of consortium, which is an interesting argument. A consortium claim centers around the notion, sort of loss of affection is the other way you'll also hear it. So to give you some examples, and I apologize for the graphicness of some of these, but if someone, we had a case one time where the person's face was badly burned, and one of the general damages that we took into account was the fact that her mouth was so badly damaged that she'd no longer be able to kiss her children. They couldn't kiss her in the same way they could have before. And what is that loss of physical affection like? You'll also see loss of consortium damages for sex, for other types of intimate acts, but the physical, emotional toll that it takes, and the tort reform folks will always be like, oh, pain and suffering, and kind of try to play it off as these people are sort of gouging the system. But I had a client one time, and really fascinating. He was a mountain climber and really enjoyed climbing, despite the fact that he lived in Texas where there's not a ton of mountains, but he would travel a lot, and that was something he really enjoyed doing. And he was so badly injured that he'll never be able to do it again. And so one of the questions that we were going to raise before the jury is, what's that worth? The thing that you love to do the most, you can no longer do. And how much is that worth to you? And that's hard to put a number on. And so that's where those general damages get really tricky. And so obviously you look at precedent, you look at what other people have been paid for those similar types of damages, you look at history to find out how that works. And that's really what the lawyers will argue. But for you, as you start to see these claims and the costs of them, just be thinking about that. Punitive damages are exactly what they sound like. We want to make sure you never do this again. Watch the recent Volkswagen case that's going to come out. They're going to get sued, and there's going to be some punitive damages put on that. When you look at the tobacco manufacturing cases, the breast implant cases, this is how much will it cost to discourage somebody from society? To discourage someone from doing this harm to society in the future. We want to make sure schools don't do this anymore. Ergo, we are going to assess punitive damages. When we get to student cases, I want you to revisit this issue of punitive damages and start thinking about fraternities and hazing and institutional liability and national fraternity liability and local fraternity liability, regional aspects of it for those fraternities that are just regional fraternities. That's one of the questions that come up in these cases is how much should there be a punitive aspect to this to get them to make people from stop doing these bad things to each other, or at least be more invested in having them stop do it. Some of the defenses, moving on to slides 19 and 20, one of the defenses is sovereign immunity. It's taken from old days where you can't sue the government, you can't sue the sovereign. You can still sue the government. It really only applies to public entities. It doesn't apply to private entities. Private entities will try a thing called charitable immunity. But sovereign immunity can be overcome. It's not an insurmountable defense. It is a defense, though. The other type of defense, if you look on slide, I believe 21 for you, is the assumption of risk. And that's what we talked about again, these issues of there's certain things that you just take on. I think in your reading you had the West Virginia case about the rugby player. When you look at waivers and how they're signed. And I want to talk about waivers for a few minutes because, there are those who might say things like, the waivers aren't worth the paper they're written on and things like that. And that's simply not true. Waivers are worth the paper they're written on if they're well executed. And so what they look at is, are the parties going into this on equal footing? So when you sign a waiver, for example, if you decide to go to one of, say, the indoor climbing facilities, and you sign a waiver, you sign your right to sue away. Now that waiver has some value if it's properly executed. So we'll talk about gross negligence in a minute, but I want us to be thinking about the idea that that waiver, if properly written and the facility is properly cared for and the instructors are properly licensed, you're signing that waiver on equal footing saying, I don't have to do this, I want to do this, and I know there are risks involved. If you've gone whitewater rafting, if you've gone climbing, if you've gone on zip lines, if you've gone scuba diving, you've signed these waivers away. If you go to the gym, you sign a waiver. Now, you don't have to engage in that activity, and they have sort of the power because they want you to sign on this activity. So you look at, this is where the unequal footing piece comes up with club sports and athletics because, you do have to do that in a way if that's the a requirement of your scholarship or a requirement of your course. And so can they have that sort of equal footing if it's something you have to do? And that's what they look at. There are some states that prohibit. If you're going to have waivers, your general counsel is always going to be reviewing them. Or let me say that again, your general counsel should be reviewing them. If you are going to make a waiver for a class trip or anything, I'm going to ask you to not reinvent the wheel. There are waivers out there that exist. Your school has them already. They've already been reviewed by counsel. If they don't, find one from another institution that has, and then have your counsel take a look at that one. But generally speaking, those waivers are valuable when they're done properly. So it has to assume what? Proper instruction, safety. This is why when you go to a gym and you sign a waiver, part of it says, hey, I know how to use this equipment, and if I don't, I'll ask somebody, and they'll have staff available who's knowledgeable. If they have staff that aren't knowledgeable, you can see how that can create a problem for it. So when you look at these different cases, make sure you take a look at it. whether there was waivers and whether there was equal footing. You have the cases where they say, hey, they signed away their right to sue us. They can't sue us now. Well, perhaps they can't, and you should take a look at that. Every state has some sort of Tort Claim Act. I mentioned this briefly earlier. Generally, they try to put a limit on the amount of damages that can be recovered. So Virginia, for example, I believe it was $250,000 per claim is your limit. And so when you look at some of the limits in those settlements, they're heavily impacted by the limit that the plaintiff could recover. Some tort claims acts can be overcome by this concept you see on slide 23, gross negligence. And gross negligence is an intentional conscious failure to do something that is incumbent, or doing intentionally failing to do something. And so you want to make sure that you don't do this. And so again, intentional conscious failure to do something, or we did something that we were not supposed to do intentionally. And so if you really want to look at the cases that involve gross negligence, it's a way to overcome immunity as well. You'll also see the term occasionally there, something that shocks the conscience. It's so grossly negligent that any reasonable person would have not just done this, but would have been assumed that it would have been done. So, this is why you look at the cases where let me say this way, gross negligence can be increased foreseeability. So we have, I'll use a suicide case. So we have, or self-injury, you have somebody who is engaging in self-injury over and over and over again. We have counseling services available. We have on-call counselors 24 hours a day, but we feel like that student has used up their time with our counseling center. So we're not going to let them, not only are we not going to let them use our counseling center or counseling services, we're going to tell our counselors, hey, when you get the call from this one, don't respond. Let the community services respond to that, not us. You're kind of creating an interesting argument for, you have this available, it's something you could have done, it's something you do for everybody else, it's something you're not doing now. Is that grossly negligent or not? And you'll see in your book some other examples of this. It's worth taking a look at. A large body of the work around the liability and negligence cases really centers around alcohol. And so we need to take a look at the way that is. So you take a look at the Kruger case where the 18-year-old young man dies of alcohol poisoning, and you start looking at the costs of that. And again, it's another MIT case, and I believe the final settlement was around $6 million. And the question is, they used some of that money to set up a scholarship, but the question there is, did MIT owe a duty, and did they breach that duty in the supervision of the individuals? And of course, you have the individual liabilities there as well. But just a really interesting area as you go on through. Now, dram shop liability is the liability that a licensed vendor of alcohol owes to third parties for injuries resulting from serving a minor or an intoxicated case. 42, maybe more now, states have some sort of dram shop. So this is why bartenders have to be trained. This is why you might get cut off by somebody before you go get in your car or walk out, because they can absorb some of that liability. Social host liability is for an individual, and I think about 32 states have it right now. I'll double check that number before our next class. But that is, I'm at a party. I'm not a licensed vendor of any sort. I don't have any sort of training, as it were, but there's that reasonable bit. So you host a party at your house, everybody gets drunk, and then they start leaving, and you've been providing the alcohol and the jello shots and all this kind of stuff. Think about fraternity parties, think about rugby parties, think about residence halls that used to host parties back in the day. For those of you who are younger, like back in the day when the drinking age was 18, residence halls on a lot of campuses, public and private schools, would host parties. They'd host keg parties right in like the quad of the hall or right out front. There was this big argument about whether that was safe or unsafe, and you had less alcohol poisoning then. I guess I should point that out. But certainly nobody's driving anywhere. Everybody can just walk back to their room. After the drinking age changed to 21, of course, you saw a lot of that sort of drop off from that. We're going to talk when I come back in our next lecture, when we revisit this issue, about the issue of strict liability and how that might attach during in a dram shop case. Generally speaking, though, it's difficult to hold a campus liable in tort for a drinking death. It's difficult to hold a campus liable for hazing. It's difficult to hold a campus liable for things that happen when a student's been drinking, unless that campus, again, we're going to go back to the notions of what either the campus was serving it, the campus organization was doing it, or the campus was on enough notice to know that this was more likely to happen. That foreseeability question keeps popping up. And so I want us to revisit the alcohol issue a little bit more when we get to the students. We're going to spend a lot of time with the students because that is really a primary area of risk right now. When we think about the Title IX cases, we think about the behavior intervention and the suicide cases. We're going to keep coming back to these. I've given you some interesting stuff there. Gary Pavella is a well-known and not just a friend of mine, but a great scholar on any number of these issues involving liability. An attorney, worked at Maryland for a long time, works at Syracuse right now, and I've included sort of his sort of top 5 on the kind of tips for you, if you will, in terms of Pavella on tort liability and for abuse and crime, and some overviews from his writings in 2004 on general liability and general risk. Please do know a couple of things, that if the employees facilitate, and we're going to revisit this at the student area as well, if the employees facilitate the drinking, really common version of this. So employees go on a study abroad trip, they all go to the UK, and the professor's buying everybody beer. You know, that can attach the institution or the individual in that. So you take a look at that. There's any number of cases dating back from the 80s into the mid-2000s on this. If the university encourages or fails to adequately discourage that faculty member from engaging in an unauthorized behavior, that's going to come up. If we know students get drunk and they climb up on this rock in the middle of campus and we don't do anything to do it. I was on a campus recently where they have said rock and they have built this fence around it. And when I was talking with them, I was like, why the fence? You know, tired of having the rock painted, or what happened? They're like, no, everybody, after a game, we win, we go over, and all these kids get on the rock and they want to take their picture with it. And if it's raining, they still get up there and they're drunk as can be. And we had students continually falling off of it. And then finally one student fell and did some very significant injury to themselves. And we ended up settling this lawsuit. And because of that, you know, there's a fence around the rock now. Another case out of Louisiana where they had a pond that they built a fence around, but the fence was poorly maintained. And they knew that students would get drunk and crawl through the holes in the fence that were pretty numerous and go in the pond, and then somebody drowns. And they're like, hey, you knew this was so dangerous, you built a fence around it, but then you didn't bother to maintain the fence. And so you can see how, again, even though the students are doing it drunk, and you might say, hey, they're drunk and they're doing stupid things, the institution can still be attached in some of these cases. So again, prohibited campus, facilitation of alcohol drinking, these are all pieces of the puzzle you want to take a look as you're taking a look at Gary's writing on that. I'm trying to keep this video to an hour or less because I want to supplement this in class, in our next class session. Also, I don't want to make you watch a 2-hour-long video because I think that would be less engaging. And we're going to go through some more cases of this over the next while. I'm not going to spend a ton of time right here on defamation other than to share with you that it is, in fact, a claim that we do need to pay attention to. We're going to get into the issues of defamation by photograph when we talk about the revenge porn stuff that's going to pop up with the students in, if not next week, the week after. Like I said, we're going to spend a tremendous amount of time on the student issues because those are the ones causing us the most liability at this point. But a defamation, just so you hear, people throw the term around a lot, and I don't want us to do that. And so defamation is a false statement made by one person to another about a third party, which subjects the third party to contempt or ridicule. And so when you think about libel or slander, the duty is that institutionally we would not make statements about other people that are slanderous or libelous or defamatory. And so it kind of goes right over the hump of whether or not there's a relationship that creates that duty. The question really comes to whether or not we can defend it. And the purest defense of slander or libel on the defamatory case statements is truth. And so if I say, for example, that Professor Smith is a terrorist, and I put that out there in the world, a couple things have to happen. Number one, you have to believe, in fact, that Professor Smith is a terrorist. So whoever I tell that to needs to believe it. They may not have to literally believe it, though, as a matter of fact, if they still do damage to Professor Smith's reputation. Now, a couple of quick things I want to make sure that we look at there is the higher up you get at the institutional ladder, the more likely you are to be a public figure. And satire and free speech issues begin to crop up here. So if I say things about Professor Smith that are satirical and that no one would possibly believe, then that can happen. Or the college president, I draw a cartoon depicting the college president as something, and I'm the cartoonist for the newspaper. We're also going to have some free press issues that pop up there when we get to First Amendment. But there are things that we can say if you think about The Daily Show and you think about the Colbert Report when it was on, and things that are said about individuals that are clearly not true and could be considered defamatory. Public figures can be exempted from being able to file those claims. The other thing about defamation I want to make sure you have to understand is proving the damages can be very difficult. You have to actually show that you were damaged in some fashion. So I need to have lost my job, or can show how that reputation caused me undue emotional harm. We get back to generalized damages. But something usually has to happen. Where this pops up very often is, for example, a faculty member, and I'm going to say things like, the faculty member says, I don't want to write a letter over to the student conduct office that does academic integrity that says that Scott was cheating in class, because then that could be considered defamatory, and then I'll be in trouble for defaming him. Well, it's not defamatory if you believe it to be true, and you have to do that as part of your job. Now, if you wrote in that paper or that incident and then circulated it amongst all professors that Scott is a serial cheater and he's cheated on every test and you can't prove it, but you just know it's true and he's a cheater, and then I'm damaged reputationally, I can't get letters of reference from other professors, there's all sorts of things that play into that. When that happens, that may create an issue. But again, I'd have to show those damages. So these are difficult things to prove. That's why you don't see a ton of successful defamation claims. When they do make the news. But we need to understand that sometimes you can say things, satire. Sometimes you can say things, free speech, not believable. Sometimes you can say things, I'm going to say something about you that is true, and that's not defamatory. You may not like it, but it's true. And then we'll revisit free speech when we get to issues around what used to be called Juicy Campus and is now called, it takes on many iterations, but we're going to talk about the dirty.com and Yik Yak and ratemyprofessor.com and things like that. And so we'll keep doing that. Again, there are a couple of things called slander per se, loathsome disease, abilities in a business that can cause damage. I believe Trump has filed any number of suits on this kind of issue in terms of people commenting on his ability to do business. And that he'll threaten and sometimes actually sue. The lack of chastity of a woman and crimes involving moral turpitude. Again, if they're true, however, if you challenge, and those are sort of old legal concepts, so take the Title IX piece as you will. But if you say that somebody's a child molester, we're going to have to factor in, is that true? Are they actually a child molester? Is it the public figure / comedy? Again, we'll revisit that at First Amendment. Where was it published? Did anybody believe it? Really interesting case we're going to unpack when we get to First Amendment, and you're going to see a lot of this defamation stuff pop up. Risk management versus risk avoidance. I have borrowed the risk management rubric to give proper academic credit to that I believe was first developed at Texas A&M. Ms. Novak, who used to work there, and some of her colleagues put together these nice matrices for student activities, and so that's really there for you to peruse. And then our plan for next week is, again, we're going to revisit faculty, we're going to revisit torts, and we're going to talk about admissions grading and financial aid, and then we're going to spend the bulk of our time handling all the other concepts as they apply to students and liability. But we're going to return to these concepts involving tort over and over and over again as they apply. And you'll even see some tort-like concepts applied to different types of cases like Title IX cases. We'll talk about a negligence case where they applied negligence to the training of a student conduct board in Tennessee. And so the student cases, I think, really bring to light how the authority, tort, and First Amendment and the other constitutional and statutory claims come to bear. They kind of all wrap together really nicely in the student cases that we're going to unpack. So we are coming up on 1 hour. I appreciate you downloading this and look forward to the rest of our semester together and the revisiting of these issues in class. So I will see you. My next class with you is on the 26th, so I'll see you then. And thanks again.